Here is what happens when bad officers cross the line and have to face the consequences. From the street to the courtroom, this one's got layers. Like, subscribe, and watch it all play out. On December 8, 2022, Stephen Bartle, a security officer at the Thousand Trails Verde Valley Campground in Cottonwood, Arizona, contacted the Yavapai County Sheriff's Office. He asked for a police escort since he was worried about potential escalation so that park manager Scott Woolley could address problems related to a member named Corey Drew. Deputy Samuel Contreras was the first on the scene. He located Mr. Drew inside a white truck parked off to the side. Activating his emergency lights, he pulled in front of the vehicle. Within minutes, 5 additional officers showed up. Everything that happened next was recorded, both on body cams and on Mr. Drew's phone.
911, what's your emergency?
This is Verde Valley, Thousand Trails. We need the sheriff.
Okay, this is the sheriff.
Hello, this is a security officer here. We're having an issue with a guest who's become aggravated and is now threatening if we approach him.
Okay, and what is he doing?
He's threatening. He's sending texts to us because we're not answering all his questions properly, and now he says if we approach him, his PTSD is getting aggravated and it could escalate if we approach him. He wants to have the sheriff escort him down to site A42 when they arrive.
Okay, and then he wants us to go over there and escort to the mail.
He would like to be escorted down to talk to this guy, yeah.
Does he have any weapons on him that you know of?
We don't know that.
Okay.
Are they on the way, by the way?
Yeah, I do have help started that way. Is he white, black, Asian, or Hispanic?
I do not know.
You don't know what he looks like?
I haven't seen him, so I don't know.
Okay.
So are they dispatched already?
Yeah, I do have help started that way, sir. Okay. I did let them know that he is at the office right now with your manager, okay?
Do you have backup coming?
We have units responding.
Okay, thank you.
Yep. Mm-hmm.
Bye-bye.
Well, step out of the vehicle, please. What? I'm on private property, boss. Have I broken the law? Step out of the vehicle, please. Have I broken the law?
No, but this officer safety, we don't know what's in the vehicle. We'd like you to step out and we can talk to you.
Well, this isn't a traffic stop.
Step out of the car. We're giving you a lawful order.
Step out of the car.
This is not a traffic stop.
Step out of the car.
And I have not broken a law.
Well, I'll tell you what, you're under arrest, so get out of the car.
Get out of the car.
What am I under arrest
Disorderly
for?
conduct, get out of the car.
What disorderly conduct?
Get out of the car, we'll talk about it, but right now you're resisting arrest.
Get out of the car. We're going to drag you out. We're going to break your window, drag you out. Don't do this.
What conduct did I do that was
Disorderly conduct. It's a criminal charge.
Disorderly conduct?
ARS 13-2904. Anything that disrupts the peace of another. Get out of the car. You're under arrest.
Wait, you witnessed disorderly conduct to arrest me?
Get out of the car.
Is there a sergeant here?
My lieutenant's right here.
Okay,
Get out of the car.
Disorderly conduct to arrest me, Lieutenant?
We're trying to talk to you.
Well, he's saying I'm under arrest.
So once we're on the window, we'll talk to each other.
Well, am I under arrest or not?
We're doing an
So I'm
investigation.
not under arrest and they
Okay,
just
but
threatened
you're
to
being
arrest?
detained. You're being lawfully detained.
Okay, I'll agree with you there.
So why not act like you're normal for
Am I under arrest like this officer?
Okay, what did I just tell you?
You said I'm not.
What did I tell you? That you're being detained, right?
At first, Deputy Contreras informs Mr. Drew he's being arrested for disorderly conduct. However, when Mr. Drew asks if any officer witnessed his alleged disorderly behavior, Lieutenant Frank Barbaro intervenes, explaining that Mr. Drew is not under arrest, but being detained in accordance with the Section 13-2904 of the Arizona Revised Statutes. This statute states that disorderly conduct occurs when somebody intentionally or knowingly disrupts the peace of a community, household, or individual through violent acts, aggressive behavior, or excessive noise. This includes hurling insults, threats, or gestures in a way that could easily incite a physical confrontation, as well as deliberately causing prolonged disturbances to interrupt lawful assemblies or events. Potential offenses extend to ignoring official orders to leave an area when public safety is at risk, such as near fires, emergencies, or hazardous situations. Another serious form of disorderly conduct involves the reckless use or brandishing of weapons or dangerous objects. Most of these violations are considered misdemeanors, but if weapons are involved, it can turn into a felony. The actions described by Mr. Barbaro may align with misdemeanor disorderly conduct, but there was no indication that deadly weapons or dangerous objects were involved. As such, the officers likely only suspected Mr. Drew of committing a misdemeanor offense. Under Section 13-3883 of the Arizona Revised Statutes, peace officers are authorized to make felony arrests without a warrant when probable cause exists. For misdemeanor arrests, however, a warrantless arrest can only occur if the officer witnessed the offense and has probable cause to believe the person did it. Mr. Drew correctly noted that since the officers didn't see any disorderly conduct firsthand, any misdemeanor arrest under the state regulations is unlawful. Assuming that the officers had seen the exchange between the campground staff and Mr. Drew, it's still unlikely a court would consider it enough probable cause for an arrest. The video evidence doesn't seem to indicate any disorderly or unlawful behavior.
Sir, please step out of the vehicle.
No. Okay. So I said I'll talk to you.
Okay, do you have any weapons in your car?
I'm not going to answer any
Okay,
questions.
because this is a big difference between us taking you out or not. So you can run down the window the whole way and let us see your hands, or we're going to break you out of the car. Roll down the window. Okay, this isn't a negotiation. Bro, we're getting to the point where this isn't a negotiation, okay?
I understand my rights. I have no officer.
Okay, well, if you understand your rights, there's a Supreme Court case that says you have to get out of the car. Okay, this is a lawful traffic.
On private property?
We are stopping you. Okay,
So
do you want to argue about this, or do you want to talk about why we're here?
I want to know.
Let me see
you
both
said I'm
your
under
hands.
arrest, and you said maybe. Now I'm not stopped for a traffic stop. Clearly,
You're being legally detained. Okay,
to
now we're going to knock
investigate
this out.
something. To investigate something?
Yes.
Okay. What are you investigating?
Disorderly conduct.
Okay. Where? Well, I wasn't disorderly. So, what do you want to know?
What happened?
Mr. Drew's continuous refusal to get out of his truck ultimately earned him multiple charges, including resisting arrest, failure to comply with lawful orders, and failure to provide identification upon request. According to Section 13-28 of the Arizona statute, resisting arrest involves knowingly interfering with an officer's attempt to arrest you. This can involve using or threatening force, doing something that might physically harm the officer or others, or even refusing to cooperate in a nonviolent way, also known as passive resistance. While Mr. Drew's actions didn't involve threats or physical resistance, a court could interpret his refusal to get out of his truck as passive resistance. However, the statute also requires that a legitimate attempt to arrest must have occurred for the charge of resisting arrest to apply. Initially, the officers informed Mr. Drew that he was under arrest. However, they swiftly modified their statement, clarifying that he was only being detained. This distinction could provide Mr. Drew with a valid defense, as he could argue that no formal arrest attempt occurred, and therefore he was not resisting arrest. Under Section 28-622 of the Arizona statute, failing to follow a lawful order from an officer, especially one directing traffic, is a violation. However, this law is specific to public roads, so unless another law applies, Mr. Drew's situation might not fall under this charge. Given that Mr. Drew is on private property and the law does not explicitly cover private property, a court would likely conclude that he cannot be charged with disobeying a traffic-related police order in this situation. As for his final charge, failing to stop or provide identification, that's classified as a misdemeanor under Section 28-1595 of the Arizona statute. This applies when a driver doesn't pull over for police lights or sirens or refuses to present their license after being stopped. However, in Mr. Drew's case, there is no evidence suggesting he refused to stop, as he was already parked when the deputy turned on his lights. Additionally, the video evidence does not show any indication that he refused to present his license.
What?
I mean, I have on film me just talking to him. Very, he was not. We weren't.
So I tried to arrange a meeting with this guy. We had an incident. He got in one of my security guys' face last night, so I tried to arrange a meeting with the guy. Then he got all pissy on a text with security, even though I'd sent him an email to meet with me about his actions. So then he came up and just stormed the office. Okay. Very combative. We have a history at one of the other parks of being combative. He recorded me the whole time. I just wanted to have a professional conversation.
Describe combative. What does that mean?
Raising his voice extremely high.
Okay, so yelling?
Not listening to my side. He's recording me.
Was he?
He tried. I have a kind of a line crossing tried to, and he got in my security guy's face last night.
Okay.
So I just wanted to have a conversation with him this morning about our rules and policies. As he escalated this morning. I tried to do it in a professional way. And he said we've aggravated his PTSD, and all I tried to do was talk to him about the rules and policies, and then it got to this.
Okay. So, how close was he when he was yelling at you?
Oh, within 3 feet. But he was yelling and using it as what the conversation was last night. So it wasn't like he's very intimidating. I mean, that's all I can say.
Was he cussing?
No cussing.
Okay. Did he threaten you?
Just said he was going to take it to legal and corporate. And
okay. So what are the text messages?
So this is what concerned us at first. The security officer basically said that we were going to meet with him at 8:42 at 10:30. He says, "Are you refusing?" And he says, "Why are you being invasive? Please give me the manager's email." I sent him the email with all my contact information. Then he says, "Act like no one is safe here, and you're rude, immature, and evasive. Now you made me unsafe and aggravated I will only communicate. Do not approach me, or else things may escalate." So we thought, well, this is kind of getting out of hand. And then we just called because we needed some backup, because obviously wasn't going to get a regular conversation.
Mm-hmm. Okay. So, what are you guys wanting done?
Well, he can't really stay here.
Do you want him trespass from the property?
Yeah, he can't.
Okay.
And I said, I need you to leave the property and we'll deal with this outside, or, we'll deal with this after the fact, but he can't be here acting like this, and he's already intimidated one of my staff last night. He's intimidating to us.
Okay.
So he can't really be here.
Okay. All right. Do you feel, you keep saying he's intimidating and combative, so combative.
Very argumentative.
Just argumentative? Okay. Was he squaring up with you, bowing up?
No, just.
Okay.
No.
Okay.
I don't think he's threatening my safety, but he's not listening to comments.
And you guys don't want him here anymore because of him violating whatever policies, rules you have?
Well, at this point, since it's got combative like this,
okay,
and that it's going to escalate, and even though he didn't even respond to my email about meeting with me,
okay,
and then he just came
but
to the office.
You want him trespassed now, and you want him off property now?
Mm-hmm.
Okay.
Yeah, I have users right. I paid $6,500 to be a member in it.
Okay. Is this your call?
No, it's
Who's calling you?
Yeah,
yours?
yes, sir.
All right, so here's the deal. Basically, do we have disorderly conduct?
with him. It doesn't sound like it was necessarily disorderly. He was argumentative, went into the store or whatever, and last night had gotten into an argument and gotten into a security guard's face. That was last night. Today he went in there basically doing this, argumentative, yelling, screaming.
He was yelling and screaming.
No profanities, no threats. He was about 3 feet away from the guy the whole time. He said he felt intimidated, but he didn't feel like he was like in.
Wasn't trying to start a fight with them.
No,
like if you look at
and
the
I asked
disorderly
him-
conduct statute, I mean, does this guy fit the statute?
Disturb the peace of another.
I mean,
Well,
Property. Yeah, I see what you're saying, though, yes.
These guys are, so they're.
Yeah, I see what you're saying.
I don't know
just
if you could disturb the peace of somebody who isn't at
Right.
peace at the
I
time.
see what you're saying.
It's like if I'm starting an argument with you and you're arguing back with
Yeah,
me,
it's mutual. I got you, yeah.
So basically,
So I think
and then I don't think they could trespass this guy because
it's private property.
you buy into this.
I mean,
So,
they might
he's
be
a member.
they might be violating their own policies or their own whatever the heck, and they might have a lawsuit on the civil side, but it's still private property. They can kick him out if he wants.
Yeah, but he's
Okay,
part
so-
of an owner
so-
though.
Okay, so he's not just camping here?
So
He's in an RV spot. He's like one of these other RV guys. It's no different than like a hotel, isn't it? I mean,
I don't know. Let me ask this dude what's
Well, let me go ask him real
That's
quick.
it,
Like,
because he said
what's-
he paid $6,000.
Oh, I
so
didn't hear
like,
that.
like if he's a member in this, and
Is that any different than like a timeshare guy that buys into something and staying at a hotel? Like, it's no different.
So as far as the hotel goes,
Well, okay, so let me ask you this: are you guys willing to f this guy up? Because that's what's going to happen.
no, I don't.
mean, we're gonna-
I'm not here
Yeah.
to.
No, absolutely
So-
not.
I'm not here to fight or
No,
anything like
absolutely
that.
not.
So that's what I mean. So we got this murky civil process. So why are we going to put ourselves in a line? Because it really doesn't change our life if we walk this guy or not.
Except for
because-
the trespassing part.
Well, I'm
He's
not
not-
sure if he is. And
Okay.
if we don't know for sure that he's trespassing,
Yeah.
I mean, like, let's look at the trespassing statute and see. But if he's not absolutely trespassing, if he has some type of property rights to this, then
I'm going to go ask them what exactly his role as far as does he live here temporarily? Kind of like does he rent basically?
He has 20. Here, I got some paperwork in here. I can show you.
And then
He has
also, is that what I'm thinking too, is that, you know, you can't just, when you look at some of these are like residential things, like that guy and these guys with the porches. So, you know, that's what it makes it look to me like more of a landlord-tenant thing, or maybe they might have to, their corporate might have to sue this guy to kick him out of the park.
I see what you're saying.
You know, because he's probably violating the terms of his contract. You know, there's probably some language in there that says, hey, I can't be an asshole when I'm staying here, but that's not us to enforce. You know, so,
Right.
you know, that's what I mean. It's like we could seriously put the hurt into this guy.
Yeah.
Well,
something.
and that's not the route I want to take.
No.
I mean, but that's where it's going to go with this.
I mean, not that this is anything, but the reservation number, and they got a 21 night reserve in and out, so it's not like he's got his member number though. So
Yeah.
I don't know what this means in
Yeah, we got to
comparison.
kind of figure out what his deal is as far as property rights.
Buy a membership in, it ranges from like 6,000 to 16,000, and then you pay monthly yearly dues. The reason I'm staying is because I have a right to stay and I haven't done anything wrong.
And we're going to figure that out. All right, thanks.
Corey, I apologize. I made a mistake in saying that you're
I
under
really
arrest for
appreciate that.
disorderly conduct.
All right. Okay, so he says that he has basically like a timeshare through Thousand Trails.
It's a membership. We control it. It's a privilege. It's not a right.
Okay.
And I mean, we could basically suspend him or terminate his membership at this juncture for acting like he is. So he has no rights to be here
Okay.
at all.
So how long does
He
he?
doesn't lease the site. There's no tenant-landlord agreement or nothing.
So he doesn't fill out any rental agreements or anything
No.
like that.
No rental agreements at all. It's a right to use contract. I even put all of our rules in here related to the issue last night, and all of our membership rules.
Mm-hmm.
And one of them is being disruptive. We're not abusive or disruptive behavior. That's one of them. You know, I know if he has a service animal, we have to be respectful of that, but the dog wasn't under his control. It wasn't leashed. He had an electric vehicle in the lodge, which we don't allow vehicles in the lodge.
So that's your guys'.
Those are all our rules that
That's
I
your
sent
rules.
him.
As far as so he hasn't filled out any lease agreements,
No.
or rental agreements.
They're just right to use contracts to use our facilities. That's all they are. And so at this juncture, we could submit him up for suspension or termination, depending on how he goes with this.
Okay. All right. Well.
So it could affect his future usage of our membership, but there is no tenant landlord.
Hello, security.
Just hang tight for me, okay? ALT. I'm terrible with names. Corey, right? Yeah. Okay. All right, you're free to go. And I'm going to ask you. You don't have to.
Yeah.
Would you be willing to show me the recording?
Yes. I will show you of in here.
Of the incident?
Now that we're done, you release me and we're good to go. I'll shut off my phone and
You're 100% free
I'll just
to
show
go.
you so that you can get the tone of what was going on there. And
Did we get his name from Hey, Corey.
From the plate trouble.
Did we? Okay, can we double check on
Yeah, I
that?
double check it now.
Okay. What kind of dog you have?
Lab.
Just a lab?
how are you doing? Oh, good. How about yourself, man? How's life treating you? Good. Okay, so This is the security office. So you can just see it here. So here's security when he says I was out disorderly at security. So I'm walking around. I think it stalls for a second because he.
You guys just want to watch that. I'm gonna go talk to them. Okay. So after talking with my lieutenant, so we think this is more of a civil dispute between the two. Okay, between the company and him. So I'd recommend going to court to get him taken away from the property, evicted, never to use the company again.
Well, we don't need to go through court. We can suspend him today.
That's
But
gonna
how do we get him off the property?
Again, we're being told that he has some sort of agreement that he's allowed to. Okay.
No.
But we don't know. Okay. So we're gonna leave it at that. We're gonna tell him that he's not to have any contact with you and any of you. Okay. And vice versa. You guys just leave him alone. Now, if something disorderly happens to the point where he's threatening, okay, meaning I'm going to hurt you, I'm going to kill you, I'm going to break whatever, I'm going to burn stuff down, whatever, or he's trying to fight you guys, okay, squaring up, bowing up, getting in fighting stances, cussing at you, yelling at you, call us, because then we can come back, okay, because that's disorderly conduct.
But by our rules, and he's subject to our rules, if we can ask him to leave at any time.
You can ask him.
Yeah, but he's not going to.
But we can't force him right now. And talking with my lieutenant, he's agreeing that we're not going to force him to leave. Okay, because it sounds like a big civil issue between you guys. Does that make sense?
I guess that's. I mean, in other incidents we've had before with similar issues, we haven't had that problem with asking someone to leave. I think he's just really pushed the line.
Mm-hmm.
I mean, I know we're hearing some of what he's saying. I mean, I know he's putting you guys in a bad light too.
Mm-hmm. It's just that we have to listen to both sides. We have to come up with a solution. Okay, and we've determined that there's no crime.
No, there is no crime.
Okay, so that's where.
No, just breaking member rules.
And that's not a law crime. So does that make sense? So.
Yeah, it's still competitive.
I know. So. But okay. Well, just if something else happens, call us. Okay. All right.
Okay. Thanks.
All right.
So I'm walking around. I think it stalls for a second because he.
You guys just want to watch that. I'm gonna go.
Do you go inside the office? No. This one.
I can't. It's the sun when you face it that way.
Which way?
When you face it that way, it's in the sun and you can't see it as well.
Hello. Hi. Hey. What's going on? Hi.
That looks like that's that. Right. That one. So then.
Why did that stop recording though? Was your interaction done with him?
I walked away. I was like, this is gonna get, and I just walked away.
Convenient.
Convenient. What's convenient?
Oh, nothing.
You have the other ones on there?
What's convenient?
The fact that you stopped recording when you wanted to.
When I walked away, it was convenient.
Yeah.
Dude, what is your problem, bro? Are you looking to? You see this? Are you recording?
We're all recording. I'm recording. I'm not hiding anything.
Good. I'm gonna get that body cam, bro.
Okay.
I'm gonna file a complaint on you. Okay. That's out of line.
Do you have any other videos?
Convenient? You know exactly what you meant by that.
You're choosing to record what you want.
I'm recording the whole interaction. I turned and walked away. And you're telling me that's convenient? Were you there? Do you know what happened? I'm trying to give you evidence right now, and you're starting to you.
I'll leave LT. I'm sorry. That was my mistake.
Alright, man.
I apologize, sir. I'm leaving. Clearly, I'm aggravating things.
This guy's fun. Alright, man. Yeah, you shouldn't have said that.
Yeah, no, I f***ed up. I'm sorry.
Because I was going to try to talk to him afterwards and ask him not to put this shit on YouTube.
Well, that was going to happen anyways, so. I said convenient.
Once everything had settled down, Mr. Drew left the scene with no more trouble. The next day, he filed a formal complaint with Lieutenant Joe Johnson at the Yavapai County Sheriff's Office and uploaded his own footage of the encounter online. In a lawsuit filed later, Mr. Drew revealed that Lieutenant Johnson got back to him on December 20, 2022. Johnson admitted that not everything had been done right. When Mr. Drew asked for clarification, Johnson said he would be looking into civil rights concerns and reviewing communication strategies with the deputies involved. He also mentioned that the department was rolling out new training for its patrol officers. Mr. Drew's video started gaining attention online, and the sheriff's office began receiving complaints from viewers. On December 27, Mr. Drew informed the department that he wanted to take his complaint further. In response, Lieutenant Johnson, who had previously been dismissive, changed his approach. On December 29, he instructed Deputy Larry Hooten to reopen the investigation. Mr. Drew was arrested on February 16, 2023, and charged with 2 counts of disorderly conduct, 2 counts of making threats or intimidation, resisting arrest, failing to follow police orders, and refusing to provide identification. He decided to represent himself in court. On February 15, 2024, the court dropped the charges of resisting arrest, failure to comply, and failure to identify because there was no probable cause. Mr. Drew filed a motion to dismiss the remaining charges under Arizona's anti-SLAPP statute, which in most states protects people from legal action over public speech. SLAPP refers to strategic lawsuit against public participation. Unlike other states, Arizona's law, revised in 2022, extends this protection to criminal charges. Arizona's law is officially called Strategic Actions Against Public Participation, SAAPP, a distinction from the more familiar strategic lawsuits against public participation, or SLAPP. Arizona's anti-SAP law offers a powerful shield against legal action, except in cases of serious crimes like drug trafficking, violent felonies, or riots.
ARS 12-751. I was claiming they retaliated against me for filing a complaint and putting the YouTube video up of the false arrest. SLAPP stands for Strategic Lawsuit Against Public Participation. It's used to protect people against lawsuits or criminal charges that are filed in retaliation for exercising the First Amendment. Anti-SLAPP motion can be filed at the beginning of a case and is meant to save people from having to go through the burden of filing a whole motion to dismiss or even go through the discovery process just to prove that they were being retaliated against. In my case, the judge ended up accepting the motion and ordering the state to respond and setting an expedited evidentiary hearing. So for whatever reason, probably because they kept losing, the state decides to change prosecutors from Cynthia Giltner to Kevin Crow. At the evidentiary hearing, the state ends up only calling Sergeant Hooten and does not call Lieutenant Johnson or any of the alleged victims. After all that, I end up winning, again, and the motion is granted. It's the first time an anti-SLAPP statute has been used to dismiss charges in a criminal case in any state.
Suppose someone is charged with petitioning the government, free expression, lawful assembly, exercising free speech, protesting, or filing a complaint. In that case, they can ask the court to dismiss the case. However, for the law to work, one must present enough evidence to prove that the charges are retaliatory and aimed at punishing them for asserting their rights. If the defendant provides evidence of potential retaliation, the burden shifts to the government. Prosecutors must prove that the charges are grounded in legitimate legal reasoning, not payback. They could try to do this by showing, for example, that the parties involved in filing the charges had no knowledge of the defendant's activism or that they treat similar cases in the same way. Mr. Drew showed the court enough evidence to indicate that the charges were likely retaliatory for his complaint and the video he shared. The prosecution couldn't dispute this, so the judge dismissed the remaining charges on March 1, 2024. A few weeks later, on March 18, Mr. Drew filed a federal lawsuit against Thousand Trails and the staff involved in his arrest, representing himself in court. On April 19, he filed another lawsuit against the Yavapai County Sheriff's Office and the officers involved, again without a lawyer. Both cases are still in progress. In the end, the actions of the Yavapai County Sheriff's Office in this case were problematic. Mr. Drew was threatened with arrest without sufficient legal grounds, subjected to what appeared to be retaliatory actions after filing a complaint and sharing video evidence, and charged without probable cause, despite the initial acknowledgement of potential violations of his rights by the deputies.
I'm not going to go over the whole thing because it's pretty long, but part of the judge's order reads, "The court finds that the defendant has established prima facie proof that the filed criminal complaint constituted a legal action against defendant, and that such action appears to be substantially motivated by a desire to retaliate against the defendant for the lawful exercise of his constitutional right to pursue a personal complaint against Yavapai County Sheriff's Office deputies." The state's response to defendant's motion to dismiss asserts that ARS 12-751 is not applicable, as the charged offenses against defendant are not a lawful exercise of the right of petition, the right of speech, freedom of the press, the right to freely associate, or the right to peaceably assemble. While this assertion is correct, it is misplaced. The state does not address the salient issue of whether or not defendant's December 8th complaint against Yavapai County Sheriff's Office deputies was a lawful exercise of the right of petition. Additionally, the state's response does not address any of the factors set forth in ARS Section 12-751B1. At the evidentiary hearing, the state called Sergeant Hooten as its sole witness. Sergeant Hooten provided detailed testimony regarding his investigation of the defendant and the evidence gathered in support of the filed criminal charges. Sergeant Hooten was unable to testify as to Lieutenant Johnson's motivations for ordering the new investigation.
Nonetheless, there was a constructive element to the situation. Lieutenant Belts played a role in de-escalating the incident, and the deputies did not arrest Mr. Drew or interfere with what seemed to be a civil dispute. However, this positive aspect was undermined when Lieutenant Johnson reopened the investigation, which appeared to be in retaliation after the video went viral. While it's important to consider the actions of all parties involved, it's difficult to view the charges against Mr. Drew as anything other than retaliation for his exercise of free speech. Mr. Drew deserves commendation for asserting his rights, filing a complaint, sharing the video evidence, and ultimately representing himself in court. Although there may have been arguments concerning his actions during the incident, the charges were dismissed and he succeeded in defending his rights. His efforts to hold law enforcement accountable reflect a commendable commitment protecting civil rights. Will his lawsuit send a strong message to the sheriff's office about the need to respect citizens' rights without retribution? Tell us your thoughts in the comments. Thanks for watching. YouTube thinks you'll enjoy this next video.